So dear guests, distinguished participants, welcome and thank you for joining our webinar on Paperless Court, How It Works. My name is David Mukarcan. I'm e-Justice Development Manager at Synergy International Systems. How does a paperless court operate? How can technology be leveraged not in some but all daily court operations to foster efficient delivery of justice? These are the questions we seek to explore today, looking at the court case lifecycle, at the same time emphasizing the presence of COVID-19 pandemic in our lives. In our previous webinars, we mainly focused on the process of successful implementations of electronic case management systems around the world. But today we want to do something different. That is to showcase our latest innovations in automating court operations and eliminating the use of paper for efficiency in access to and delivery of justice. And for that purpose, I'm joined today by my colleagues, Mrs. Naisan Karunji, e-justice expert at Synergy International Systems, and Mr. Khachatur Materosyan, Vice President of e-justice domain at Synergy International Systems. So together with my colleagues, we'll be covering the following topics. And let me quickly share my screen with you so you can see the agenda of our session today. So we'll start speaking about filing by the public of the court cases. Then we will move on to the summoning, followed by sessions and virtual court. Then we will talk about collaboration on cases, how it works and what technology provides to help us do that. Afterwards, we will talk about judgments and orders management. And in the end, we will showcase reporting and analytics tools in electronic case management systems. So all participants outside of speakers today will be muted during the webinar, but we encourage you to submit your questions via chat feature, and we will dedicate 15 minutes Q&A session at the end of this webinar. French language translation will be available by selecting French from the interpretation menu at the bottom of your Zoom window and muting original English. So let's start. And Khachatur, why don't you give us a quick introduction to Synergy and its performance in the past, in the justice sector for the past years, for our audience to get to know us. And for that, I will be happy to share again the presentation for you.
Thanks, David. Actually, if we talk about Synergy International System, so we have provided solutions to governments and organizations worldwide since 1997. We have 5 offices. We are headquartered in United States, in Washington, and we have offices in Armenia, in Netherlands, in Rwanda, and the recent one we opened in Ukraine. Up to now, we have more than 300 employees, and we have done more than 300 projects in more than 80 countries up to today. So on the map here, you see the countries which are highlighted in blue where we have done projects. And the one with the flags are actually the ones where we have done electronic case management system for justice sector institution. Currently, we have done more than 10 projects in about 5 continents, covering the United States, Latin America, the project in Guyana, which covered the several justice sector institutions. Also, we have done a project for anti-corruption investigation, prosecution, and high anti-corruption court in Ukraine, in Eastern Europe. Also, several projects in African countries, including Rwanda, Uganda, Zimbabwe, and Court of Human Rights in Tanzania. And also a project in Papua New Guinea in Pacific. And the recent one we started this year in the Kingdom of Tonga for the judiciary.
Thank you for the introduction, Pachatur. That's very impressive. Now, let's move on to the topics of our webinar today. And as I said, we will start by speaking about filing by the public. So my first question will be for Nysen. Nysen, could you please give us an overview of the process of filing court cases by the public users and what challenges they face in this process?
Thank you, David. Allow me to express this through a testimony of one of the litigants in a country where we worked with. This litigant had an appeal to file, and he had to travel around 91 kilometers to reach the court. And then he also had to travel to the bank to make the payment. So when he got back to the court, at the registry, they found that he's missing one piece of evidence that is critical to accept his appeal. Because that would mean that he would have to travel 91 kilometers again to get the piece of evidence and travel 91 kilometers back to file his appeal. Cutting the story short, he was not able to file his appeal. What challenges do I see here? Number one is that in the physical filing of cases, a litigant has to keep track of the working hours for the court and the bank. And depending on the court where he wants to file his case, that can be challenging. Now, if we talk about the international litigants, it means that a person in a different country has to board a plane, pay the ticket, go to file a case, and all the time, if he wants to follow up his case, he has to do the same. So this incurs a lot of cost, both in time and monetarily. So there are a lot of challenges for litigants in filing and follow-up of cases in a paper-based system.
Thank you, Nysen. Thank you so much. And I believe this process should be common in most of the countries and jurisdictions. But now let's see what technology has to offer in this case, and in particular, Synergy eCase has to offer to address those issues. And Pachatur will help us with that. Please.
Thank you, David. Actually, to showcase how the technology can help for the paperless court and specifically for the e-filing, we'll use one of our demo applications and we'll log in as a litigant who wants to file a case to the court. Now, I'll log in as a litigant, and in the system where I have pending my action, I can open one of the case which is yet draft, or I can create a new case and file it. But considering the time limitation, we'll just open one of the draft cases we prepared and show what information it can have and how it can be filed to the court. So if we click on the cases which are yet pending, please draft one, which is just draft and it's just pending submission to the court. So generically, when we file cases to the court, so we have some general information, selecting the court, the category of the case, adding the parties, and different type of documents that can be filed by the public based on different courts and different jurisdictions. And if we go into the general information, which is called the view mode, where we view the all information, we can go into editing. So here we are filing in the Supreme Court a civil appeal. We have the checklist which can guide the public, so what needs to be done. And if it's an appeal case, we can link another case from the system, which is an appeal, adding the parties to it. I'm as the litigant Anita, and here I am as an appellant, my respondents, and the documents that I'm actually filing. And for electronic cases in some countries, there is a need if you have several documents to compile them. So we can easily merge those documents to have a file with all pagination and information. Something like this with the hyperlinks automatically with correct pagination on all the places. In most of the countries, this is required if you're filing the package of more than 10 pages or even 5 pages to have all of them compiled together. We can upload it, and whenever we are done, Just what needs to be done by the public is to click on actions and submit to the court. At that time, court will be notified that the case has been filed and will have access to all the information filled by the public. And even if need be, if you file some files, there is also possibility to e-sign the document, and by the public and by the court will show how this works actually as well. But now, for sake of time, we'll just consider that the case is complete and we can file it to the court. David?
Thank you, Khachatur. So now that we understand how public could use digital tools to file their cases and manage them, let's talk about summoning and sessions a little bit. So courts need to communicate with public. And my first question is on summoning. And I want to ask Nysen, what happens here? How is this usually carried out? And have we noticed any issues here, taking into account also COVID-19 pandemic and its consequences?
Thank you, David. Before I address the summoning, allow me to update the people following this webinar that the testimony of the litigant I told earlier about electronic filing, who could not file his appeal in the physical setup. Years later, when we implemented the Synergy eCase for them, he testified that he was able to file his appeal in the comfort of his home and using evidence from his colleague who was in another country. And that he had no limitation with time anymore because he could file at 11 p.m., for example, and the case would be admissible as well. Now, going to the summoning, like you have said, this is an integral part for court processing. And what happens in the physical setup is that the court prepares the summon, then they have to hire a bailiff, or the court registrar can deliver the summons to the litigants. Obviously, that requires transportation costs, and or they can pay newspapers and radios to be able to advertise such kind of summons. With COVID-19, I have noticed that most of the jurisdictions are trying to use systems to have summoning and to create them. But there is still a huge limitation that such kind of systems are not able to track whether the summon has been delivered or sent or not. So still the court is not aware of whether the summons are delivered. And for this, the litigants can easily come to court and say they never received the summon or they were never summoned. And this can be a reason to adjourn hearings or to refute a judgment. David.
Thanks, Nysen. So now let's talk about scheduling sessions. What does it look like for a court that does not have any digital tools to schedule and conduct them, so in real life or in paper-based system? What it is about?
So for courts that don't have systems for that, they have to do it manually. It means that there are departments in the court that have to schedule the sessions manually, and then these sessions are delivered manually to the litigants to know the session of hearing. Depending on the country, on their laws, some laws, the summoning can contain the date, but still before the summon is sent, they have to have manual scheduling of these summons. This is a huge challenge, David, especially with COVID-19. Because it is limiting the traveling, it is limiting reaching the public physically. So this means that courts are having it hard to share such kind of information. And in criminal cases, when you talk about prisoners, this is even harder because the transportation of prisoners itself was costly and difficult before COVID, but now it is worse because if people were transported, many people in a van, now only few can be transported at a time. So it is a huge challenge with COVID-19 for different courts to schedule and conduct hearings. Now, when it comes to conducting hearings, we look at three challenges here. We can see the challenge of notification, we can see the challenge of cost, but we can also see the challenge of hearing minutes. With COVID-19, some courts have adopted the use of Zoom and Skype and other a kind of video conference applications, but still there's a limitation that how do they sign the minutes of these hearings if they can't do it physically. Yeah, so I can say that most of the challenges are those that I have witnessed in the COVID-19.
Thank you. Thank you, Nyson, for walking us through this very complex process and approaching these issues from different angles. Bearing in mind all of this, I would like to now ask Hachatu to talk about what we call e-summoning and virtual court and demonstrate how it can help mitigate those challenges. But let's start with the e-summoning first. Hachatu, please.
Thank you, David. To show the example of how the documents can be submitted to the public by the court in electronic way, I will log into the system as an assistant registrar. So now I have logged into the same system as an assistant registrar, and impending my action, I have actually more cases than the public we're checking, and I have also other documents from different cases where I need to react or I have prepared the draft and I need to work. And also one of the things that is here, we have also the possibility to implement the court rules. So if there is anything which is already overdue, to showcase them separately. Now we'll enter the cases which are already overdue according to the rules. And let's just open one of them to prepare, for example, a letter which we'll submit, and based on the letter, we will actually see how this can be disseminated electronically. So this is again a case in the Supreme Court, a civil appeal case. So we can access the part of the letters and we can create one. For example, a letter for calling heads of arguments. Now, here we will submit a letter for Anita. The subject comes automatically and it will be for today. Now, this is called the electronic form. And if we want to preview actually what is the document, the real document look like, this is actually the so-called the export template. So a document which generates automatically the case number, the dates, parties, all the information accumulated automatically. And it has a place for a signature. Now, to make it easier, we can just directly sign it. There is a possibility to put a signature, electronic one. So system gives possibility for the users to e-sign the document. And technically there are and electronic signature and digital signature with certificates. But today we'll check the option for electronic signature. And I will just put my signature here as a registrar. And here I have my signature. Save. So the signed letter actually appears in as a signed copy. Now, sometimes there is a need also to stamp some of those documents. Now we can open the documents that is already signed. And we can just put a stamp on it. Well, near the signature. We can browse a stamp. And we can add the stamp as well. So this is a document which is signed and stamped so-called electronically. Save. Now, in Synergy case, any part of the case can actually be managed fully electronically. And this is a letter which needs now to be submitted to Anita. And we can submit it physically and we can submit electronically when system will send a notification to Anita. Okay, now this is pending delivery notification. And to make the process complete, to make sure that the files are submitted electronically and they are delivered, we can go to the general information where we have the so-called notification logs, which tracks actually all the different notifications which have been submitted. And here now we have the letter for calling heads of argument, the letter which has been submitted to the party, to Anita, and just a matter of time, the system will check if it is delivered or not and will automatically update the status. This way, court can keep track which are the exact notifications that have been sent and which are the notifications which are yet pending and which ones are failed. So this way, it will be clear for the parties and for the court staff if the summoning or sending of any documentation have been successfully been done or not. David?
Thanks, Khachatur. That looks very smooth to me. So now let's move on with sessions and the possibilities of scheduling them and conducting them virtually in Synergy eCase. Please.
Thank you, David. For showing how we can handle the session, we'll log in as a registrar of a court. And now I've logged in as a registrar into the same system. And I can see all of my pending cases, but also we have different workspaces. We can open the cases which are assigned to the registrar and are pending any action from him. So here is a case which is currently pending preparation of the notice of hearing. And this is the flow which shows actually at what state our cases are. And we can go into the session section and create a new session. For example, a hearing. Now with the electronic courts, we can say we are scheduling a session for today. Today scheduling a session for 24th at 9 for 1 hour. And here are the two things that makes actually difference. If we put that this is online, system will automatically generate also a virtual hearing link and will send it to the corresponding court staff and the participants who needs to be present during the session. And if we click that this is public, system will also generate on behalf of the court YouTube account, if there is such, a public YouTube link, so the parties can participate to the session through the YouTube, so the public who are interested. And this is the court staff which will be present. We can check their availability if they have any other session scheduled for the day or any other appointments, and we can select the parties. And in the same way, like we did electronically signing the session order, we can do the same, the letter and notice. We can do the same for the registrar. We can just e-sign it or put the stamp on it as we did before. Now, this is a scheduled session, but David, should we go to the virtual hearing to see how it works for a session which has been specifically scheduled for today at around 5:30?
Absolutely. So to make this more interactive, we're going to have a real-time virtual session for our audience to see how virtual court operates in action. And to do so, we have asked some of our colleagues at Synergy to connect as users of the court staff and different parties to the case. And this session will be, and Khachatur will be the assigned judge in this session, and will walk us through this process. So please, Khachatur, let us know and see what it looks like.
Okay, I log in as a judge into the system, who is actually the one to preside the session. So as a judge, again, the system automatically shows me the ones that are pending my action. I have 4 cases, a draft order, a session I need to attend, and a judgment. And on the calendar for each user, it shows the sessions that he or she needs to be present. So I have yet a couple of minutes So I will just open the case to see what it will show me for now. Before going to the session, as a judge, I can access also the case based on my permissions. And if I want, I can just open all the documents there are inside the case. I can preview them and I can download them. And any information inside the case is available to me so I can get prepared for my hearing. And the good thing, we can open the session in parallel, even from the calendar. So here is the hearing. So we can join the hearing and see how it works. Now, the advantage of this integration between the case management and the virtual court solution is actually that there is no need to type every time the name. System will automatically show the role of the person, the assigned judge, the name, and the same will be done for the litigants, their advocates, and the rest. Now, I have joined to the session as the assigned judge. Well, and the idea of such kind of setup is that we have the speaker mod, who is the assigned judge, and we try to a bit replicate the actual court setup. And system automatically shows from the case that we can who is the appellants, the lawyers, bench members, and so on. And we have all the participants. So the judge can easily identify who is actually who. It's like the appellant, it's like a lawyer who is representing someone. And all that information is also available here, and with a possibility of a chat so that people can chat and write if they have any issues. And of course, the best thing that the judges usually like, it's the hammer functionality, which creates a sound so everybody comes to an order. And with different views, there can be a view where we can see the bench member, the court staff, and the other participants who are actually the case parties, or the speaker mode, where the speaker usually comes first. So whoever will speak, he will appear here. And giving some functionalities to the judges to mute everyone, and the court staff to us to turn their videos on or off, and so on. And all the sessions are being recorded. So when the sessions are completed, the recording will automatically be available in the case, which makes it's very much easier to actually connect and see the recording whenever is needed. So considering that whenever the session is over, we just leave the virtual session. And it's just a matter of time when in the session, system will bring all the recordings and the chat which actually happened to the case. So the judge, for future purposes, can see the recording and the chat, and all that information will be available to him or her. So it will be easier to manage and to have all the information in one place. And this can also give possibilities to have hybrid hearings when court is connected and some people are physically in the court and some are connected remotely. So this is just one of the examples how a virtual session can be set up and can be organized. David?
This is quite impressive, Bachadur, I must say. Well done. And I'm sure our participants are taking some notes right now, and questions will be raised afterwards about this too. But I want to follow up on this part and ask something that we get asked a lot. And Nysen touched upon this very briefly in her speech. So as we know, pandemic forced many courts to go online and basically choose some of the known corporate video conferencing tools for online case hearings, such as Zoom, Skype, Microsoft Teams. Could you please summarize the key differences that Synergy eCase and its virtual court are bringing to the table in this regard?
Thank you, David. Actually, having clients in different continents and working with judiciaries all across the world, what we have come to, one of the actual requirements that was there. So first we started when the pandemic came out, making integration with Zoom and Teams in our platforms. But then it turned out that people want to have actually, and specifically judges, to be able to replicate the actual court setup. So when they connect, they can easily see who is who and have really an integration with the system, so that the roles of the parties, also who are the advocates or lawyers, who is representing whom, so that this information can be clearly seen as we showed. This is one of the aspects that we try to replicate, making this kind of smooth integration. And the second one was actually to be able to have the system on premise, considering that in many countries, you cannot have the system on cloud and the data appearing cannot go outside on the cloud. I think those were one of the biggest differences that we came out to this solution, so that the judge can easily see the parties and the litigants, and he can have at the same time full access to the case, just in another tab, or if he has two screens, to have on one screen the full case and on the other file have the virtual conferencing to see the parties, different modes of viewing people and giving more tools to the judges and the court clerks to be able to access it. Plus, at the end, when the recording of the exact session is coming to the case and being available from the given session and from the given case, this makes it really easier after to refer to the recording or even to the chat that was being online during the hearing.
Thank you. Thank you for the clarifications. And now let's talk about the daily operations of the court staff. And like every institution, different individuals in courts need to collaborate with each other. Nysen, what are the standard practices of working on a single case by different stakeholders in the court, and how can this be improved?
Thank you, David. It is actually common practice that people collaborate on the same case from different departments. For example, a registrar could be preparing a summon while the president of the court is assigning judges, or a judge is preparing for the hearing while the registrar is preparing to capture minutes. And also it is most common, especially when there are bench of judges, more than one judge on the same case, and they need to collaborate with each other in order to reach a common decision. So this could always definitely be improved if there is a way for them to easily work on the same case at the same time without disrupting the other or losing information from one another. And it could also be helpful if they could do it electronically, because I'm presenting from the paper-based manual system where they have to make copies of the same file. And if they want to update the original file, it can be done by the person that has the file in his office or his docket. Yeah, so I think it could be improved in that way.
Thank you, Nysen. That's very insightful, actually. And once again, I would say that we see the limitations of a paper-based system in physical setups. But something tells me that Khachatur has some ideas on how to address them. Khachatur?
Thank you, David. Actually, to show how the collaboration can be done on a case, we'll log in again as the assistant registrar. And before passing to actual demonstration, just let me explain in couple of words how this can actually be done. So what we have tried to do in our recent technical implementation is to be able to give multiple access to the same case and to the same documents, and at the same time split the case into different components. Meaning, if we open one of our cases, for example, this one, technically there can be scenarios when more than one user needs to work on a case. And in superior court, sometimes there can be, if you have a bench of judges, like 5 judges in the same bench, you may need to have 5 copies of the information. So accessing the all updated information at the same time can be different. And imagine when public is making a payment for some files from the case, and if you want to have really fully updated information, you need to give that, you need to make a copy of that request and disseminate to 5 examples. Now, what we did is actually giving possibility to modify based on the permission any part of the case to different users, meaning somebody can work on the general information, the judge or the registrar can work on the sessions, and public can file a payment request and the registrar can approve or reject the payment request. So this way, we may have multiple accesses on the same case, and at the same time, different users with different permissions at different states, for example here, who are accessing the case at the same time altogether. Plus, there is always possibility to have online chat or commenting on a case, which can be done through public internal chat and through restricted groups with tagging different users. For example, the registrar can say that he's preparing, and when it's finalized, it will be submitted. You can write new comment and tag, for example, the judge or the assistant and so on. And in this way, the commenting can be done and on the case and on its separate parts, and multiple different groups can be created. So the bench can have their own chat group where they can exchange ideas about the order or the draft judgment. The registrar can work with the assistant registrar to raise the inquiries, and they will be notified through the notification inside the system, and even through email or through SMS notifications. But the idea is that at the same time, with this type of, let's say, splitting of a case and having all its components separately as well, in parallel, the case can be viewed and updated ad hoc, which is not available in the physical setup, physical paper-based systems. And its different parts can be modified at the same time without making any discrepancies with each other. David?
Thank you, Khachatur. This actually looks truly great. And I'm also noticing some questions coming into the chat, so please keep them coming. We will try to answer all of them in the end of the session. But for the moment, let's move on. And so the process of the court case is only complete when an order and judgment has been passed down. Nyson, what does this process entail in a paper-based system, and what challenges are encountered on the way?
Thank you, David. I will start to answer that question with what a judge needs to reach a decision, and then I'll explain a bit what the judge does while making the decision, or what he needs to do while making a decision. So the judge needs, first of all, to access precedent, to be able to determine other cases that could be similar to the one he has in order to reach an informed decision. Number two, he needs to access recidivism, to access the information about the party if he has committed crimes over again and he is a repeated criminal. He needs to access information about him in regards to the case in order to know how to decide about him. Number three, the judge needs to access all the case documents, preferably, and I speak of this because I have interacted with many judges and they explain that sometimes they need to view all the documents in the case as one and to be able to refer to particular documents if they need to. And then what the judge does when he's making decision. Obviously, all these that I say the judge needs are hard in the physical environment, because imagine if a case is only appealed, they have to transport the whole document from the lower case to the appellant case. And without saying if it's a criminal case, then they have to request the investigation and the prosecution to transfer all these files against the judge. So accessibility of documents to a judge in a physical environment is very complicated. And also knowing recidivism of a defendant is also complicated in physical setup. Now, what the judge does is that he writes the judgment and then he puts the signature on that judgment, and that judgment is stamped and shared with the public. Again, in the physical environment, this was done physically, but with COVID-19, this presented a huge challenge for many jurisdictions.
Thank you. Thank you, Nysen. So, Hachatu, now let's talk about Synergy eCase and how it improves this process and essentially supports judges in their daily work and operations.
Thank you, David. Actually, we'll again log in as Judge 1, who was presiding one of the hearings, and we'll see how this can actually work. So basically, the hearing we completed, we don't see it anymore. We have 4 cases which are pending our reaction and 1 order, which is yet a draft, and we need to complete it. But before going to that, just to explain a couple of functionalities that can be important. Based on our discussions with multiple countries, one of the functionalities that is required for judges to make their decisions is to be able to search in the precedent cases or precedent decisions. So it's kind of to have access to a library of the different decisions which are available to judges for cases from different instances so that they can refer to it and access it. Now, one of the possibilities that we have in the document search, if we type any word, system will bring to the judge all the cases and all the information from different documents that the judge has access to where the word appeal is present. And this can be printed, downloaded, or previewed online. And even from here, judge can directly access the case. And at the same time, there is extensive filtering possibility to be able to filter and say exactly we want the orders or we want the summons or any other document, or even filter by cases and their statuses. So this gives kind of a possibility for the judge to fully access all the information that is by permissions available to him or her to be able to write the decision and make references to already pronounced decisions or pronounced cases. This is one option. The other option is that the judge can have full access to the information about the parties. For example, if we open one of our cases, which is pending decision pronouncement, so hearing has been done, and we go into the party screen where we have the case parties. So system gives possibility to see not only the case where the party is present at this stage, but also to see all the other cases where the party has ever been present. And this way, judge can know if this is someone who is the first time in front of the court, or this is someone who has been several times in front of the court. And based on, again, his or her permission, the judge can access those cases. Plus, if it's an appeal case, judge can also access the originating case just from here, from his case. So he can have online access to all the information. Plus, in many cases, for all the documents that have been signed or uploaded into the system, the judge can have direct access from the document section. System will comply. And if even need be, he can merge them, as we showed for the public, to have one document with all the pagination and hyperlinks as PDF, or even export all the documents, so to make kind of a bulk download, so that in the end, you can take them home and read them if you want. But in most of the countries, those systems are also available through internet, so that if there is internet, the judge can access and read those documents online. Now, for making the order, again, most of the information, the judge can make an order, which can be a draft, or it can make a judgment. So it differs between between countries and jurisdictions. But for the orders as well, judge can make a draft order, which will be only accessible to him or her. And as a public, the judge can sign the order, or as a registrar, just again, make a signing of the document or stamp it as well. And if if it's on another page. Just to put the signature and sign. And if the judge has made the signature, which is not correct, he can edit it, undo it, or the signature can be saved, so all the time not to redo it. And there is a QR code, which actually works for then searching the document. So any document which is signed or created in the system, it gets a QR code, and through the QR code, it can be searched in the system through the QR search. Now, the document is in the signed copy, and it can be signed for registrar signature, or if it's signed by the registrar, then this can already go and the order can be published. And the advantage is that based on the permissions, this type of orders can be available to the litigants, or if it requires payment to get the order, so this can be done through the payments and then be available. So this is fully permission based. But in the concept of the paperless court and for the increase of the accessibility of the orders and judgments, in some countries, when there is electronic case management system, orders or judgments upon their pronouncement are being available to the parties. And in other countries, there is a fee which is required to be paid, so those information can be available. David?
Thank you, Khachatur. I was actually going through the chat questions, and they are very specific and detailed, and they are welcome as well. And using this opportunity, I want to note to all our participants that if you're interested in more detailed presentations of the spoken features and functionalities, we'll be happy to discuss them in separate calls and demos after the webinar. Of course, trying also answer those questions in the end of this webinar. But now let's imagine a situation where it's the end of the quarter or end of the year and courts need to present reports on their performance. We all understand the complexity of such efforts in paper-based systems where the data needs to be collected manually, compared with each other, etc., etc. But when you have electronic case management systems and your data is online, there are certainly better ways to do this. Let's see what Khachatur has prepared to show us for this part.
Thanks, David. Actually, one thing is then we have all the information in electronically, but the advantage is when you are able to analyze all the information that is there inside the system. So I'll show a couple of examples of reports, how analytics and online reporting can help to facilitate the life. I have logged in as a secretary who has access to all the information at country level, and this is just a demo data. So this is example of a report which shows at this stage how many pending cases we have, how many pending payments, and number of pending sessions, plus the performance of closed cases per court and per case categories, and pending cases per each court that we have, and pending draft documents. Different type of payments that are there and which are pending, and scheduled sessions during the month. Now, if we have pending cases, we can have this so-called drill down. So we can go into the pending cases and see them per category. And if, for example, how many urgent chamber applications we have, how much appeals, and how much court applications, and go into the pending cases per court, which will be for constitutional court, and the court application types. And from a, let's say, a country level or a court level, drill down to a case level and access the cases directly from here. And just go back to see in Supreme Court or commercial court how many cases we have. And in the same way, we can drill down to many other reports, like for the pending payments, we can as well access the pending payments, which are pending, see their due dates, and so on. And the same for the sessions to see not only the overall statistics, but go into the exact sessions per case and see, and also make a filtering. or access the cases directly from the reporting module. And also to be able to download and export the pages in PDF or any other file format, a full download or download a specific chart or export a specific chart and or report and so on. David?
Thanks for elaborating on that, Khachatur. Before starting the webinar, I was going through the list of participants and noticed many of them are from the IT departments of the judiciaries and the Ministry of Justices. And some of the questions in the chat make me think that maintaining this type of systems and their sustainability is another point to pay attention to. What would be your approach in looking into this question?
Thank you, David. Actually, before sharing the screen and showing how it actually can work, just to give an overall understanding what we understood on, based on our more than a decade of experience working with different judiciaries and justice sector institutions. The justice sector rules and processes, they are not fixed. So every time we provide a system in a country, then the rules, for example, if we take an example of a court, the rules can change and the processes can change. New report requirements may come out for the analysis and statistical purposes. New forms can come out. The deadlines for different type of operations can change. And starting from the very simple, we need a new field. It can be a new form, a new notification, or a total modification of the rules if there is a major update. Now what we try to do is to make sure that we can come up with a solution. And this is one of the advantages to make it more sustainable, that people will, even not being a developer, software developer or database developer, they can maintain the system and can enhance and add new forms or functionalities. Just not to make our session very technical, I will just show a couple of examples how all this can be done. I will log in as an admin user who has access to the system fully. Now, for the reports that we were viewing here, we can just add a new report and modify the existing ones. We can just put a table report. And say we want per court, for example, to see overall number of cases, open, closed, pending, and so on. And adding a new report is just a matter of seconds. In the same way, we can have and modify all the system from the organizational chart, having new users, new roles, new groups, new permissions, and we can configure any form that is in the system. For example, the case that we're opening in case edit mode, we have all the fields which we were looking, and we can just drag and drop any field from here to there, and it will appear in the forms. In the same way, there is no need to have special developers to maintain. Every time there is a need to have a new field or a new form in the database, all this can be created online without having necessarily access to the source code or the database. The same way, if there are any changes in the court rules, so all the changes can be managed through the administration center from the business rules. So new rules can be set up, and it can tell all the deadlines, and based on this also to manage the performance. And of course, all these type of changes which are being done are being monitored in the audit, where any action being on the case, it shows. So I think this was one of also another question for the security purposes. So anytime there is any action on a case, a login, create action or update, all this is being captured, and also the views we will vote for the security purposes. So the idea is that every time there is anything to be done, for example, the document that we're viewing, letter for calling heads of argument, the document that the registrar signed. So all the text is here. So every time there is a change, this can be changed here. So every time a PDF or another file is generated, so everything can be modified. And this way, one of the biggest advantages is that the courts don't need to replicate a setup of an IT company with 20 years experience to maintain such systems. Having system administrators who are trained for several weeks that can fully have and maintain the system. David?
Thank you, Khachatur, and thank you, Nysen, for a very insightful and productive discussion. I'm sure your comments and recommendations will be very useful for our participants and their institutions. And now let's go to the questions that we have gathered from the chat. But before doing that, I want to assure our audience members that those questions that we will not answer today during the Q&A will be answered individually via emails. So let's begin with the first question. And the first question I want to ask, I think it should be addressed to Khachatur, and this is kind of a group question, combined a few questions together because it's on the same topic. And it's about the virtual court. So one of our audience members is asking whether the virtual court is our Synergy specific video conferencing tool. Have we designed that? And whether our system can be integrated with other known video conferencing tools such as Zoom, Google Meet, etc. And also, what happens when the sessions are public? Where could they be streamed?
Thank you, David. Actually, yes, the system can be integrated with other virtual solutions. Let's say other video conferencing solutions if they have web APIs, because Synergy's platform can be integrated with any solution actually which has a possibility to integrate with the web-based applications. Whatever relates to the public hearings, so what is the solution that we came to, and this actually works very well, is whenever scheduling a session, it is marked as public. There is automatically a YouTube link created. So I can show just an example. Here, this is just a demo data. Every time a case is getting a hearing virtually, which is marked public, automatically on YouTube at the demo website, we schedule the sessions automatically. And in the system as well, if the court has a YouTube account, they can schedule a live transition. So from here, just if the YouTube account is put, this can be configured and automatically the sessions will go in case they are public. For the other question, which was asked also, the system can be multilingual. We have systems which have at the same time 4 languages. We have systems which are in French or even in Arabic with totally different interface. So just answering that question at the same time. And the solution that we came out is actually based on open source open video technology, based on which we do the virtual conferencing, but it can be changed. The only thing that we came with the judges interface is that not all the virtual video conferencing solutions allows other organizations to modify fully their interface, but to be able to replicate the actual court setup, it is done through the through the open source technology that we use. And it can be deployed on premise, so the data will not go onto the cloud.
Thank you. Thank you for the answer, Khachatur. And the next question, again, I'll combine them because a few of our audience members are asking about integrations of different softwares into the Synergy eCase. And two of the examples that were brought up are the any possibility of integrating a digital recording system to Synergy eCase. And the second question is there an integrated instant transcription of the hearing, or does the registrar has to work on a separate system?
Thank you, David. Actually, for the transcription and capturing the minutes, so different options are available. It actually depends if there is any voice-to-text solution at the court, or if the recording can be set. But there is always possibility to manually input the data from the proceeding, which will be separately from the audio-video recording, like based on each party, the question and answers, and so on. And if there is a solution which in the courts for a transcripting and any other, which can again be integrated with a web-based solution, so integration can be done.
Thank you, Khachatur. And I'm going to ask the last question of our session today to Nysen. It was directly addressed to her. So the question is the following: when judges study their case using paper-based system, they naturally feel comfortable to flip over between pages and then taking notes. How do you find the experience of judges in this area from the usability aspect?
Thank you, David. It is true that most judges, especially the older ones, prefer the paper-based manual system because they can flip through pages. But from the experience we have had in the different countries where we have implemented the system, we have noticed that judges prefer convenience more. So if they know that they have a web-based system which they can access in their farm or in the comfort of their home and be able to write judgments or sign them or inform litigants or interact with the system, they prefer that more. But also we have had numerous experiences in change management that we have used for such kind of challenges. And what we have experienced is that with time, the judges actually start to love the system and want to use it more. And they don't want to go back to the paper-based systems anymore. So I think it is a mechanism of change management, but when it comes to usability of the system, it requires trainings for the end users, and it is considerably very user-friendly for the judges to adapt.
Thank you, Nysen.
And David, if you allow, there are questions if the system can be francophone. I will just answer
of course.
French. Oui, le système peut être en français. Il peut être pas seulement en français, il peut être en quelques langues aussi. Merci.
Great.
I have no idea what he said, but that's what he said.
So the French question, trying to answer in French.
That's great. And this brings us to the end of our session on Paperless Court, how it works. I want to thank everyone for your time and attendance. We will publish the recording of the webinar in English and French on YouTube and share it with you. For the questions that we didn't answer today, we will definitely get back to you individually. Once again, if you want to have more in-depth discussions and system demos, we will be happy to organize that. Feel free to reply to one of the emails you received from me. Look forward to staying in touch and hope to have you in our next webinars. Thank you and goodbye.
Thank you, everyone. Bye.